The sources of the law. As the terminology of science and philosophy comes mostly from the Greek, betraying their source, so the language of the law comes mostly from the Latin. Law in general was jus, justice or right. Lex meant a specific law. Compare French droit and loi, German Recht and Gesetz. Jurisprudence, wisdom in the law, was defined in the Digest of Justinian, AD 533, as both a science and an art. The, quote, science of the just and the unjust, and the, quote, art, that is, administration, of the good and the equitable. Jus included unwritten law, or custom, as well as written law. The latter was composed of jus civile, the law of Roman citizens, and jus gentium, the law of the nations. Civil law was public law when it related to the state or the official worship, and private law when it dealt with the legal interrelations of the citizens. Roman law as a whole flowed from 5 sources. 1. Under the Republic, the ultimate source of law was the will of the citizens, expressed as leges in the curial and centurial assemblies, and as plebiscita, decided by the plebs in the tribal assembly. The Senate acknowledged leges only when they had been proposed to the assemblies with the proper formalities, and by a magistrate of senatorial rank. When Senate and Assembly agreed in passing a measure, it was proclaimed in the name of Senatus Populasque Romanus. 2. The Senate itself, in theory, had no lawmaking power under the Republic. Its Senatus Consulta were, formally, recommendations to the magistrates. Gradually, they became directives, then imperatives, until in the later Republic and under the Empire, they took on the force of laws. Altogether, the laws passed by the assemblies or the Senate were so few in the course of 6 centuries as to astonish one accustomed to the legislative flux of modern states. The need, 3, for minor and more specific laws was met by the edicta of the municipal officials. Each new urban praetor, our chief city magistrate, issued an edictum praetorium, announced by a herald in the forum and inscribed upon a wall, and stating the legal principles on which the praetor proposed to act and judge during his year's term. Similar edicts could be put forth by circuit judges, praetores peregrini, and provincial praetors. Through their power of imperium, or rule, the praetors were allowed not only to interpret existing laws, but to make new ones. In this way, Roman law combined the stability of its basic legislation with the flexibility of praetorian judgments. When a law or clause was carried down from one praetorian edict to the next for many years, it became a definite part of the jus uraniarum. By the time of Cicero, this law of the offices had displaced the 12 tables as the main text of legal instruction in Rome. Nevertheless, a praetor often reversed the decisions and sometimes contradicted the principles of a predecessor, so that uncertainties of law and arbitrariness of judgment were added to the abuses natural in every judicial system operated by men. It was to end this uncertainty that Hadrian instructed Julianus to unify all preceding jus honorarium in a perpetual edict alterable only by the emperor. 4. The Constitutiones Principium, or Statutes of the Princes, became themselves in the 2nd century a varied source of law. They took 4 forms. A. The prince issued edicta by virtue of his imperium as an official of the city. These were valid for the whole empire, but apparently lapsed after his death. B. His decreta as a judge, like those of other magistrates, had the force of law. C. Imperial rescripta were his answers to inquiries. Usually they were epistolae, letters, or subscriptiones, brief replies written under a question or petition. The wise and pithy letters in which Trajan answered the requests of government appointees for instruction were incorporated into the laws of the empire and kept their validity long after his death. D. The mandata of the emperors were their directives to officials. In the course of time, these came to constitute a detailed code of administrative law. 5. Under certain circumstances, law could be created by the responsa prudentium. It must have been a pleasant sight when learned jurists sat in chairs in the open forum, or in later decades in their homes, and gave legal opinions to all who asked, taking their chances on some indirect remuneration. Often, their advice was solicited by lawyers or municipal judges. Like the great rabbis of the Jews, they reconciled contradictions, drew subtle distinctions, interpreted and adjusted the ancient law to the needs of life or the exigencies of politics. Their written replies, by unwritten custom, had an authority only less than the laws. Augustus gave such opinions full legal force on two conditions: that the jurist should have received from the emperor the ius respondendi, or the right of giving legal opinions, and that the reply should be sent under seal to the judge trying the case in point. By the time of Justinian, these responsa had become a vast school and literature of the law, the fountain and foundation of his culminating digest and code.